So we are going to continue with Erica case. I know that you are fed up with Erica, but it's a very interesting case, and I think that is good case to recap how the liability regime works in practice. Okay, just first a very quick recap of about the CLC fund regime. I think that you have understand. So we have the first tier, who is liable under the first tier. Owner of the ship. Okay. So the basis of liability, the principle of liability of the ship owner, strict liability. Okay. And the compulsory insurance, it's obligatory. Yeah. Okay. For the ship carrying 2,000. Okay. And remember the alpha case in Greece. Then the second tier and the third is financial responsibility of IOPC fund. Okay. So, so this is financial liability of all oil receivers in state parties of the fund convention. Okay, so talking about the Erica case. So what happened? Here on the slide you have the basic facts about the case. So Erica was a tanker, and on 12 December 1999 broke in the Bay of Biscay in the EEZ, exclusive economic zone of the France. So the stern section of the ship sank to the depth of the 130 meters and approximately 100 meters of the bow section. Erica, at the time of the incident, was carried 31,000 tons of heavy fuel oil. It's a persistent oil. And here you can see how much the oil was spilled at the time of accident. As some oil tons of oil of cargo remained in the bow section, and some in the stern section. Here you can see the place of the incident, of the Erica incident. So it's within the EEZ of the France. Consequences of the incident. So the Erica caused, it was the biggest oil pollution in the European waters and caused very serious pollution with France territorial water and its coast. So 400 kilometers of shoreline was affected. Also coastal fisheries, mariculture, tourism sector, self-production area. So all they were affected by oil pollution. Also seabirds, so were recorded. So some 740,000 oil birds were recorded along the coast of the Bay of Biscay, and half of them were dead. So why did the Erica sink? So the investigation of the incident has shown that sinking, the main reason of sinking, the sinking of the Erica was the lack of the maintenance and the corrosion. So the sinking was caused by weakening of the structure of the section 2 of the Erica, so leading to the succession of the ruptures, which caused the whole structure to collapse. We have already said that the French court had jurisdiction regarding criminal liability and also regarding the civil liability. So, and we also have said that at the time the France was state party to the new CLC foundership. Here, just to recap, the persons involved in the management of the Erica. So the Erica was registered in Malta. Registered owner of the ship also was from Malta. Manager of the ship was Panship, charterer, we have already said this total FINA, total as a holding company, France company. Classification society of the Erica was the Italian classification society. What? RINA, yes. And liability insurer, so was the P&I club from Bermuda. So we have already said that criminal court held criminally liable for the offense of causing pollution the representative of ship owner, the classification society, as well as Total as the charterer of Erica. So, so I would like to ask you some questions to see did you understand how the CLC fund regime works? So, and referring to the scope of application requirements, some civil liabilities, scope of compensation. Okay, so some questions we have already answered during our presentation, but perhaps the first question, so try to explain whether and why do Erica accidents falls within the scope of the application of the CLC liability regime. Whether and why. So I will just, this is the, about, so we are here, what type of the ship was there? Tanker, so, yeah. Okay. Okay. The whole scope of application requirements are fulfilled. Do you agree? Yeah. So the Erica was a tanker, was carrying heavy fuel, and also the territorial scope of incident was in the under the geographical scope of application under CLC. Okay. Explain who is, in your opinion, responsible for damage in this case. And do you think that liable person could be exempted from the liability for pollution damage? So who is responsible under CLC convention? The ship owner, okay? So
the other question could be damage. I think the answer is no, because we agreed that it wasn't reckless, it was negligence.
It was negligence, okay. Some other opinion? Okay. Yeah.
And all the other parties,
what do you want to say? So to counter games to so, but you think that the ship owner is liable for the?
yes.
Okay, and what with other persons? Classification, charterer, what we have said about the liability. And what is about the channeling provision? What does it mean? Oh, how it will perhaps? Who benefit from the channeling provision? the charterers, and yeah. Yeah, they're excluded only if it proved that they caused the damage with the intent and the recklessly with the knowledge. Okay. Could you enumerate the potential admissible claims for occurred pollution? And do you think that the impact on the seabirds could be compensated under the CLC fund regime? Okay, here you have the impact. So the pollution, the cost of preventive measures, then the economic losses from local fisheries, mariculture, tourism sector, salt production areas, and so on, and then also the seabirds. So, what will be the scope of the scope of compensation? Okay, but so what do you think about
beneficial to loss
economic loss.
I think they could make a claim on the CLC only if the birds were a big tourist attraction, or they were eating the birds and the eggs. But if not, they couldn't bring it to the CLC.
You think that it's ecological damage per se, so it's
because before the CLC was said that can only economic losses. And I think it's already the first question is already enumerated here. So
okay. Some other opinions? You agree with? Environmental damage. For environmental damage. Yeah, so we have already said in the morning section that according to the IUPC found that the environmental damage to environment per se is not admissible. But in the Erica case, it was, but not under the CLC convention, not under the French national law. And I think that they compensated the local authorities at some environmental organizations. So organizations, yeah. But it was also interesting that the damage was not documented. So they just, they used, I think, some abstract models, so. But in some cases, we don't know what was the condition before the incidents. The condition, the stage of the marine environment. So it is very, very difficult, to calculate. So this is the reason why the IUPC, the IUPC criteria said no compensation for damage to environment per se. So to avoid the abstract methods of calculation. So, and then the last, to what extent do you think the victims, the oil pollution victims, can be compensated under the CLC regime? Is there a limitation of liability? And do you think that the persons who suffered pollution damage could be compensated by IUPC fund?
You mean suffer directly or suffer pollution?
So is there a limitation or liability in the CLC fund regime?
Yes.
Is the ship owner liability limited or unlimited under the CLC? Okay, yeah. Yeah, so but the liability is limited here. If we, where is I put the same? Yeah. So this is the first. This is the first tier, and then what is the with second tier? Do you think that they can be compensated to the IUPC fund? Mm-hmm. And the third? Huh? Yeah, it's not because it's that time the France was only and it does exist. Yes, the third tier was adopted in 2003. Yeah, it was united. So it was the supplementary protocol to IUPC was adopted after the ERICA and Stitch.
Actually, it was adopted because there was a fear that the damage will exceed also arising out of the ERICA accident will exceed also the limits of the 1992 fund.
And perhaps one question more. What do you think about the problem of uniform interpretation of the CLC and the fund regime and convention? So what do you think about the legal status of the? We have said that the IUPC fund adopted a manual. Guidelines regarding the scope of compensation. Okay, so the criteria how they calculate the type regarding the type of damage and its calculation. So, what do you think about the legal status of IUPC claims guidelines? Soft law more. So you think that the national courts are not binding?
They can, but are not obliged to do the
Mm-hmm. Yeah, you are correct. So yeah, because of that we have different interpretation of some terms in convention by national courts. So okay,